Today we're going to talk about arguably the most dangerous case yet that the Supreme Court has agreed to weigh in on, and I have two interviews this week. Former federal prosecutor Glenn Kirshner joins to talk about who Trump likely pardoned and how we know, whether there's any reason the DOJ wouldn't indict Trump, and what Trump's legal recourse would be if he's actually charged. And I'm joined by Michigan Law School professor Leah Lippman to discuss if the federal government can use federal land to offer abortion care, whether states can try to ban medication abortion, and the chilling new case that they just put on the docket for next term. I'm Brian Tyler Cohen, and you're listening to No Lie. So we've spoken at length about the spate of recent Supreme Court decisions, including the gun decision in New York allowing people to carry firearms in public, limiting the EPA's ability to enforce the Clean Air Act, and of course, most recently overturning Roe. I honestly think that these are going to be the issues that define the upcoming midterms, and rightfully so. These are part and parcel of the Republican agenda. This extremist court has opened the floodgates for extremist state legislatures and governors to force an unpopular agenda onto their constituents. And it's not just the Supreme Court that's doing it. This is all happening in a coordinated effort by Republican operatives whose only goal here is to impose minoritarian rule, basically far-right Christian nationalist rule on a country where 70% of people don't even want it. But I don't want to talk about those cases. I actually want to talk about a case that the Supreme Court has decided to take up for next term, and that is Moore versus Harper. It's looking to reinstate gerrymandered Republican maps that were struck down by the state Supreme Court. Even though in their ruling, the judges wrote that the Republican-led legislature, quote, subordinated traditional neutral redistricting criteria in favor of extreme partisan advantage for the GOP. But the plaintiffs in this case are arguing that this court, or really any state court, has no authority over the state legislature when it comes to elections. Basically, they're saying that when it comes to elections, the state legislatures have the first and last word, which is convenient if you're a Republican and your party already has majorities in the legislatures in most states because of gerrymandering, which is the exact issue at hand here. In other words, Republicans gerrymandered their districts, gained majorities, and are now looking to use those majorities to pass new maps and enact new laws that will make it impossible for the Democrats to even have a fighting shot to take those majorities away. And they want a 6-3 far-right court to make sure that no one can stop them. This case involves a theory called the independent state legislature doctrine, which basically says that state courts can no longer have the ability to strike down laws that violate their state constitutions, and governors no longer have the ability to veto election laws passed by the legislature. Again, it would make state lawmakers the ones with the first and last word in elections, even if the laws they're passing violate their own state constitutions. And if you're thinking, what's the point of having state constitutions if the legislature doesn't have to abide by it and the courts don't have the ability to check their power? That's a great question. And just to be clear, in case there was any doubt as to why this case is being brought right now with this court, first off, it's likely this 6-3 conservative court will rule in favor of North Carolina Republicans. But more importantly, look at states like Pennsylvania and Wisconsin and Michigan. All have Democratic governors and all have Republican-led legislatures. It is not an accident that the plaintiffs in this case are looking to give legislatures in 3 of the most critical swing states all the power over issues concerning elections and leave the governors of those states with no recourse. This isn't about any governing philosophy. It's just yet another deliberate effort by Republicans looking for any tortured legal theory in support of their conclusion. They need to give power to these Republican-led legislatures, and so they'll debut all of this fancy legalese about the independent state legislature doctrine. That is all bullshit. And this case wouldn't have been introduced in a million years if Democrats ran these state legislatures. This is about Republicans recognizing that having state courts and governors be able to check their abuses of power prevented them from stealing the election in 2020, and so they're trying to fix that in 2022 and 2024. Period. So knowing that this case is coming, and knowing that the 6-3 conservative court is highly, highly, highly likely to rule in favor of the Republicans who brought the case, and knowing what a death knell this would be for democracy, our only option here is to expand the court. And I know I sound like a broken record because I've said in the past that even if we get a bigger majority in the Senate and eliminate the filibuster and pass the Women's Health Protection Act, that this court won't allow that to stand, and so we'll have to expand the court to codify Roe. But I think the argument can be made that this is even more dire. And that's not to downplay the significance of overturning Roe. It's just to say that once Republicans are given carte blanche to rig the rules of elections in their favor, then voters won't be able to elect people who would protect abortion rights. Voters wouldn't be able to elect people who would protect any rights. This is foundational. Everything else stems from the ability to have free and fair elections. And if the Supreme Court validates the GOP's efforts to make it so that they can rig any map without consequence, then that is how representative democracy dies. So I know, again, that I sound like a broken record, but there is nothing more important than holding our House majority this November and expanding our Senate majority, eliminating the filibuster, and most importantly, expanding the court so that these far-right radicals don't have the ability to give Republicans the green light to assume full control across the country. We've got this shot and that's it. We can stop this, but it's going to take all of us staying involved and not sitting this one out in November. To check out my interview with both Glenn Kirshner, where we discuss who Trump likely pardoned and how we know, and whether there's any reason the DOJ wouldn't indict Trump, and Michigan Law School professor Leah Lippman, where we discuss if the federal government can use federal land to offer abortion care, whether states can try to ban medication abortion, and the chilling new case that the Supreme Court just put on the docket for the next term that I just discussed here, check out the interviews playlist on my YouTube channel.